Your Honor, may I make another request to brief my witness, please?
There is no statutory right for you to brief a witness. If the witness is available and you can talk with them, that's fine. But being as the fact that you're in custody, we have certain procedural safeguards that have to be followed. Depending on whether or not we proceed with the trial today, I will determine whether or not you have an opportunity to speak to her.
Shouldn't I be given the same privileges as lawyers?
You will be given the same privileges as a lawyer. And you've had that same privilege to communicate with this witness while you were in custody.
In custody through a monitored telephone conversation and chirps? That's not the privilege I'm required, Your Honor.
You are entitled to the same privileges in court as an attorney would have, but there are certain limitations on that. Because of the fact that you're in custody, you obviously have to be accorded the rights that an attorney would have with those limitations. So,
Where are you getting these rules at, Your Honor? Because I would like to read them myself.
we're gonna deal with this motion right now, and then we'll determine whether or not you have any other option regarding speaking with this witness. So you have a motion to quash/dismiss. Is the state ready on this motion?
Yes, Judge.
All right.
State
Mr.
will call.
Vaughn's, it is Mr. Vaughn's motion, and it is a motion to quash or dismiss with prejudice. So are we treating this as a suppression motion?
Yes, Your Honor. I filed this when I was asleep one night. We can treat this as a suppression.
I think the reading through the motion, the appropriate legal styling would be a motion to
All right.
suppress.
Then the state may proceed.
State would call Officer Jeffrey Clark.
You can step around, please. Hold.
Are you Officer Jeffrey Clark?
Yes, ma'am.
Do you go by Jeffrey?
I go by Scott.
Okay. But your report says Jeffrey, so Officer Scott Clark. And are you an officer or do I need to use a different title?
Recently promoted to corporal.
Corporal. All right. Corporal Clark, you arrested the defendant on August the 30th of 2022. Is that right?
Yes, ma'am.
Explain to the court what where everything happened and what was going on when you arrived.
It occurred at the Exxon gas station at the intersection of Skyline Drive and Highway 46 that adjoins the Crystal's fast food restaurant. The call that we received was a priority 1 dispatch for a disorderly male within the store.
Okay. And when you arrive, had other law enforcement arrived on scene before you?
Correct.
And who was there before you?
At the time, Agent Brad Garland and Agent Ronald Tilley with the 23rd Judicial Drug Task Force.
And
Ronald Tilley, I think so. I believe that's his first name.
Tilley. And had Agents Garland and Tilley already placed the defendant in handcuffs?
Not until I got on scene.
Explain to us where the defendant was when you arrived and what was going on.
When I arrived, they had already moved over to the Advanced Auto Parts parking lot in a Cadillac Escalade.
When you say they, who do you mean?
Mr. Vaughn and Jennifer Dozier.
Okay. And they were in an Escalade. Were they inside the vehicle or outside the vehicle?
I cannot recall.
Okay.
So you're gonna have to speak up. Pull that microphone more. There you go. Speak
There
into
we
the
go.
microphone.
Is that better?
What was the answer? Where were they?
I do not recall if they were in the vehicle or outside the vehicle upon my arrival.
And let's go ahead and cross this bridge. You were wearing a body cam at this time.
Yes, ma'am.
When you filled out your grand jury packet, you requested that the body cam be downloaded and provided to the DA's office.
Yes, ma'am.
And we never got that.
I know the DVD request was submitted. I do not know from my memory from there what happened.
Now, around that time, the agency was also having some problems with the video system.
Yes, ma'am. Files were getting corrupted and the video files were messing up.
Objection,
So-
Honor. She's leading.
Trying to remember what that actual question was. I will rephrase and continue. And did anyone intentionally delete this video?
No,
So we are left with what options on why we don't have a body cam?
I'm not sure how to answer that.
Could it have been human error
Possibly,
or problems with the system?
possibly, yes.
All right, going back to arriving on scene, the parties, the defendant was at the Advanced Auto Parts. Where were the task force agents?
They were there with them.
In the parking lot of Advanced Auto Parts?
Yes, ma'am.
Okay. You said Mr. Vaughn was cuffed after you arrived?
Yes, ma'am. After I arrived, I believe Mr. Vaughn was very hesitant to identify himself at the time after I arrived, and he had the odor of alcoholic beverage coming off his breath in person, and that's when Agent Garland detained him.
What was his behavior like at that point?
I would say irate.
Was he still causing a public disturbance?
Not as much, but being hesitant to cooperate.
Did you question Mr. Vaughn?
I asked him what had occurred at the gas station.
Was that before or after he was in handcuffs?
I believe before.
And did he give you any variation of the events at that point?
He stated to me that they had a disagreement with the female inside the gas station, and that he had held the door shut afterwards for an unknown reason, preventing the clerk from coming out. I know I have in my report, and I believe it was said on scene, that the female inside the store had issues with Miss Dozier.
Was there a search of the Escalade?
There was.
Why was there a search of the Escalade?
Agent Tilley deployed his K-9, and I believe it alerted on the vehicle, and there was a search, probable cause search conducted from there.
Was any contraband located in the car?
No, ma'am.
Was anything pertinent to this case located in the car?
There was an ID with Mr. Vaughn's name on it that was used to identify him, where he was hesitant to identify himself.
Did you ultimately decide to arrest the defendant?
Yes, ma'am.
Why did you arrest him instead of cite and release?
With the number of charges that I had at the time, I felt it was more pertinent to make an arrest.
Would you normally cite and release someone for an assault?
No,
Would you normally cite and release someone for a false imprisonment?
no,
Would you normally cite and release someone for a public intox?
no, Your Honor, no, ma'am.
You said you smelled alcohol on him. Was there anything else in his behavior or demeanor that indicated his level of intoxication?
I'm not sure.
But you didn't do like field sobriety tests or
No,
anything?
ma'am.
All right, Judge, I will pass the witness.
Vaughn, you may cross-examine.
Officer Clark, is it?
Yes, sir.
How you doing today?
I'm doing good. How about you?
I'm doing all right. This case that we're here for on today, do you recall the date of that case?
I believe August 30th of 2022.
2022. So, did you read any reports today, or is your memory just that good?
I'm just referring to my report. from the
Referring
case.
for a report, okay. So just from the report, that's what we're gonna base all these questions off of? You answered them from your report, basically?
Pretty much, yes.
Okay. At the time of this incident that we're referring to, was you present at any of it? Did you see any of it?
No, I did not.
You didn't see any of it. When you arrived at the scene, what was you a witness to?
Testimonies from the victim and talking to you.
What about any other testimonies from Jennifer or the other officers present?
Jennifer was hesitant to say much of what happened.
Okay, what about the other officers?
They just gave me the download of what because I was not far behind them.
So
when
you
I
didn't get
responded.
firsthand knowledge of any of this?
I believe, honestly can't answer to most of that, but I know I was not far behind the agents when I was responding to the call. And they might have told me something, but off the top of my head, I cannot recall.
Okay, so you just have trouble remembering, correct?
It was 3 years ago, so yeah.
Okay, so the time barrier made it troublesome for you to remember what happened?
Sorry.
The time barrier making it troublesome for you
Yes,
to
sir.
remember?
Yes, sir.
Okay. When you arrived at the scene, you said that we were at the auto parts store.
Correct.
Can you recall where me and Miss Jennifer were?
Off the top of my head, I cannot.
How many officers do you recall that was at the scene when you arrived?
When I arrived, it was 2 drug task force agents
Okay.
and myself once I got there.
Let me see here. You said that when you arrived that there was a search, correct?
Later on, yes,
Was you present for this search?
I was.
So you was? Was there a dog at the scene?
There was.
There was. And you said you had a body cam present?
Yes, sir.
Did anybody else have a body cam?
I cannot answer for the drug task force agents because they have their own agency and director and everything. So I can't answer for them. I know when I was present, I had a camera and it was on, yes.
Okay, what about your patrol cam? Was that on too?
Should have been, yes.
And you don't have either of those?
I do not. That was a different recording database brand or whatever you want to call it.
So when you get these recordings, do you submit them?
When we had that software system, those cameras were downloaded daily by plugging them up. The dash cam and car cameras were recorded with an SD card inside the camera. And every pay period, those cards were given to the shift sergeant to be downloaded into the software.
And what happened to them between that time and getting to the courts?
They would be in the software, and then around the time of the grand jury packet, I put a DVD request in for it,
So there was an error somewhere, the reason it didn't make it to the courts?
possibly.
Okay. Could there have been any errors committed that night that you arrested me?
Are you asking technological wise, or?
Yes.
Very well could be.
Okay. So when we come to cite and release, is that a mandatory or officer's discretion? Is that
It
what
is
you're talking?
discretion.
It's discretion.
Correct.
Okay. Did you you said that you smelled alcohol.
Correct.
Did you give any breathalyzer test?
No.
Did you give any field sobriety test?
No.
Did you have any blood drawn?
No.
And you wasn't present for any disturbance at the Exxon, correct?
No.
So you arrested me without a warrant?
You were placed in my custody, and a warrant was drafted and then presented to a magistrate.
At the police station?
Correct.
Okay. So I was arrested, correct?
Correct.
Okay. Without a warrant?
That's how it usually is. A warrant's drafted. You're placed in my custody, a warrant's drafted, and then presented to a magistrate.
Okay. And you stated there was nothing found during the search of the vehicle?
Negative.
But they said a dog did hit on something, so that would be a false positive, or?
I cannot answer to how the workings of a canine are because I'm not certified in that. That would have to be for an officer that has that certification.
Okay, did you see this dog with your own eyes?
I did.
Okay. Okay, so you don't recall me being in handcuffs and sitting on the sidewalk when you arrived?
I cannot recall off the top of my head now.
And then being transported over you and y'all switching handcuffs?
We would have swapped handcuffs at some point, yes, because
Okay.
I do recall Agent Garland detaining you, but I do not recall what you're asking. But I will say, that way I'm not taking that agent's handcuffs, I would have done a cuff swap on you, yes.
Okay, and when I was placed in handcuffs, was I placed in the back of the police car?
You would have been placed in the back of mine.
Okay, and then the investigation continued?
I cannot recall, but more than likely, I probably went and talked to the victim at the gas station.
Okay, why didn't you get any statements that night?
It would have been the recorded statement of the victim and then what she told me.
You didn't think she needed to reduce that to writing?
Didn't think I needed to, no.
Also, I seen in your report that, you witnessed you witnessed a store camera of some hands up in the air.
She showed me a still shot from the cameras that she took on her phone.
Did you get a copy of that?
I did not.
You didn't think that was reasonable for your investigation to get a copy of that?
It was just my eyes and my testimony.
Judge,
Just-
we're going into general cross. This has no relevance to the motion.
It has relevance to proving that, there was improper procedure, Your Honor, that you put that in your warrant, that you had video camera, then why didn't you get a copy of it?
Judge, if we could have a ruling on the motion.
Motion is sustained. Your objection is sustained.
Okay, let's see. Other questions I got for you. Did you get a statement from Jennifer that night?
Did not.
When you were viewing this camera, was there any other witnesses there?
I believe there was people inside the store, but they were not identified and they did not stick around.
Did you think you need to get their witness statement?
That's up to them if they wanted to stay. I can't forcibly hold them there as a witness if
Did
they
you
don't want to
question any
comply.
other witnesses?
I did not.
Okay, thank you, Your Honor.
Redirect by the state.
What did Bethany Page tell you happened inside the store?
Bethany advised to me that Mr. Vaughn was a daily customer and he normally came in there to buy a dip. She advised to me that Mr. Vaughn was irate with her on this day and accused her of being a CI or criminal informant for drug task force and had threatened to beat her up in the store.
Did that cause her to fear that he would actually beat her up?
Yes.
Did other customers come into the store during the time that Mr. Vaughn was saying these things?
I believe Bethany told me there was other customers in there attempting to buy items, yes.
Nothing further, Judge.
Vaughn?
You said Miss Bethany stated that I threatened her, correct?
Yes,
Word for word, can you recall what she said?
not word for word.
Did you inform Miss Bethany her right to get a restraining order?
I did not know.
You didn't? You didn't think someone that was threatened, their life in danger, should be informed that they need a restraining order?
Again, this is outside the scope of the suppression.
Sustained. It has no relevance to
Okay.
the question of whether this motion should be granted.
All right, thank you, Your Honor. That's all I have.
Thank you, sir.
Anything further from this witness? Sustained, I'm sorry. Counsel, you may step down. Oh, your next witness.
Judge, may I see if my other witness has arrived?
You may.
It would call agent.
We're going to have you come around here.
Are you Agent Ronald Tilley with the Drug Task Force?
I was
You were. You are now, what is your rank with the police department?
detective.
Detective Tilley, I will do my best to refer to you as detective, but you have been agent to me for a very long time. Now, let's go ahead and clarify, you do not independently remember much about the day when you came out and Mr. Vaughn was at the Exxon.
That's correct.
You've reviewed this report
Yes.
and still have no independent memory.
No.
So what I'd like to talk to you about and to explain to the court is at this time, you were a canine handler, is that right?
Yes.
Okay. Your dog's name was Nina.
Yes.
What certifications did Nina have?
She was certified through the USPCA as a detection dog, odor detection dog.
Okay. What odors was she certified on?
Marijuana, cocaine, heroin, and that's
And I'd like to talk about, well, and you two were certified together as handler and dog,
yes.
and you would have had an up-to-date certification at that time.
Yes.
So when Nina or any canine who's certified alerts on a vehicle, does that necessarily mean you're going to find drugs in the vehicle?
No.
Could you explain that?
Yes. So the dogs are trained on the odor of narcotics. So when they detect the odor of a narcotic or drug, they give an alert, a passive alert, such as a sit. And on that alert gives us probable cause to believe that there's narcotics inside the vehicle or box or whatever container type is there. And that's just based off of the odor.
And if a dog is alerting and you're not finding drugs, what does that tell you?
It tells me that drugs have been in the vehicle, whether they were in a case of marijuana smoked in the vehicle or somebody carried them into the vehicle and have left the vehicle with the drugs, the odor still stays around.
And again, do you remember anything about your interactions with the defendant or anyone else that evening?
I do not.
Nothing further, Judge.
Mr. Vaughn, you have any questions for this witness?
Detective Tilley, how you doing today?
Doing good, sir. How are you?
All right. You remember me?
I do.
You do, from the night of the arrest?
Previous interactions, I do not remember this particular night.
I don't think I remember you from any other. I couldn't pick you out in the lineup.
Really?
Yeah, okay. So I know you're having a hard time remembering a lot of this stuff. It's so long ago. You're just based on reports, but I got a few questions for you. When you got the call on your radio, you showed up to this scene. Why did you, as Drug Task Force, show up to this scene?
I believe, I don't remember if I showed up to the call or if I was requested out, but I believe we were just close to the area, so we responded.
Is it normal to intervene with normal misdemeanor calls like that?
Yes, if we're in the area of a call for service, whether it be a misdemeanor, felony, it doesn't matter what the call is. If we're close to it, we'll respond.
Okay. When you arrived, do you recall where you found me at?
I do not.
Maybe auto parts store or Exxon?
The report stated advanced auto.
Okay. Do you recall where I was when you arrived?
I do not, no.
You don't. All right, let's ask some dog questions. Does dogs hit for Alcohol?
No, mine doesn't.
Yours does? Oh, that's good to know. Um, do you recall, and how about this? Let's just do this. Instead of me asking you these questions and you don't know, do you recall anything from that night?
I do not know.
Um, um, I just don't see the point in this. You can't remember nothing. Your Honor, that's all the questions I have for him.
Thank you. Any redirect by the state?
The task force office, how far is that from that Exxon?
I don't know, 1.5 miles, 2 miles.
So, and my understanding of the questions that Mr. Vaughn asked, even though you're a task force agent, you're a law enforcement officer, correct?
Yes,
So when a call comes out and a task force agent is the closest, even if it's not a drug call, are they going to respond,
yes,
especially for a priority one?
yes.
Nothing further, Judge.
Vaughn, any other questions?
Yes. So you and your partner, I can't recall his name, y'all would be the first ones on the scene, correct?
I believe that's what's stated in the report.
Okay, did you make a report?
No,
Why not?
I did not seek any charges in this case. The city showed up and took over the situation.
Would you be a witness?
Yes,
I mean, you first responder, wouldn't, you don't think that was necessary?
we don't usually do reports when we're not the primary officer.
You don't do reports, but you think it's okay to show up to scenes? I mean, that seems like you're doing half the job there, sir.
No, the primary officer does the report for just about all calls. Every now and then there will be a supplemental report done for a main report, but usually the primary officer does the report for calls.
Since you brought that up, the primary officer, he wasn't present at the scene when you arrived, was he?
I can't recall if he was or not. I don't believe it was by reading the report.
Okay, so he had to receive all his information from you and your partner, correct?
I guess so.
Okay, thank you, Your Honor.
Anything further? Thank you, Detective. You may step down and you are released.
Thank you, Judge.
State may call us next witness. All right. Mr. Vaughn, the state has rested their proof. Do you wish to have any proof offered on your own?
Yes, Your Honor. I would like to call Jennifer Dozier.
Jennifer Dozier.
Yes, Your Honor.
Dozier, if you'll come around, please, and ask you to raise your right hand and be placed under oath. Mr. Vaughn, you may ask.
Good morning.
Good morning.
You know what case we are here for today?
Exxon, I believe, is what I was told.
Okay, yes, it's the Exxon case. Was you present at this?
I was in the car.
Okay, you was in the car. Do you recall my state of mind that night?
I mean, we had just left work. That's all I recall.
Okay.
We had just left from Sam's.
Um,
From Sam's, it was our boss.
see how that's gonna work. All right, when the police officers arrived at the scene, where were we at?
We were in Advanced Auto Parts getting a part for Sam's Derby car.
Okay. And what brought our attention to the parking lot?
The police by the vehicle.
What were they doing at the vehicle?
I don't recall.
Okay. Do you recall the doors being open on the vehicle?
I believe at one point they did because they said it was involved with the situation down the road.
Did you see any dogs at the scene?
Later,
later on?
Yeah.
Did you see dogs present when?
not initially, no.
Okay, okay. When we exit Exxon, I'm at the Advanced Auto Parts store. How did the officers address us?
They just approached us and asked what was going on, made us sit on the concrete and figure out what was going on.
Were we placed in handcuffs?
I wasn't. I'm not aware if he was or not. I'm gonna be honest, it's been years.
Okay. Was I irate at any time during this night?
Not to my knowledge, but
Okay. Let's go back over to the Exxon. Was there any police present at the Exxon?
no.
Was there a lot of people present, if you can recall?
It didn't look very packed from what I recall. There wasn't many cars there.
Did you see me threaten anybody?
No,
Did you hear me threaten anybody?
no.
Did you see me cause any incident with anybody at the Exxon?
I didn't see you cause an incident. You know, I heard that, you got into an argument or whatever.
Maybe
Held the
you
door
have
for a
to
second.
Speak up a little
Sorry.
bit.
I heard that you had gotten into an argument with her and then you kind of like held the door a little bit
Did you see me hold the door?
for like a split second, yes.
Why would I hold the door?
She was trying to get outside, apparently.
What was her actions, the reason I held the door?
Supposedly she wanted to fight me, but I don't even know her.
Okay, where was she at previously before?
Behind the counter,
How did she get to the door?
assuming she walked around. I didn't see that part. I just looked up and seen you both at the door, and then y'all come out. Both of you come out,
What was she doing at the door?
yelling.
Was she
And just yelling.
scared?
I can't tell you. I don't know how she reacts when she's scared.
I mean, was she yelling she was scared or angry or?
I mean, she sounded angry to my knowledge, but I don't know. Some people react and get angry when they're scared.
Okay,
You know, I do.
okay. And you don't recall, wait, you said you do recall all that. Did you write a witness statement that night?
No, not to my knowledge. I didn't want.
Why didn't you?
I didn't ask for one.
Okay. All right, thank you. No more questions, Your Honor.
General Bryson, you have questions? Thank you, ma'am. You may step down. You are not free to leave because we have a trial coming up. So
Thank
you'll
you.
step out in the hallway and just remain outside. Mr. Vaughn, you may call your next witness.
Oh, that'd be my last one, Your Honor.
All right. State, have any rebuttal proof on the motion? Mr. Vaughn, I will hear you an argument about your motion.
For first, Your Honor, it seems like nobody can recall the entire incident, my witness nor the states. The distance of 3 years is making this difficult for anybody other than reading a report, which my witness was not given that opportunity nor briefed. There is no body cam footage to prove anything that none of the officers saying. Bethany Page herself is not here to make a statement, nor does she have a written statement or a video recorded statement to justify what the officers are saying other than each other. There is no proof that any of this has happened, Your Honor. That they followed procedures like they were supposed to. There was supposed to be a warrant before I was arrested. There's no proof that I was drunk. This is a Fourth Amendment violation, Your Honor. Illegal search and seizure. There is no proof that they had any reason to open the truck doors. It just shows malicious intent of the officers, Your Honor, and I believe it'd be in the court's best decision to just dismiss this case. And then it's just in violation of statute 47-103 and grounds of arrest of an officer without a warrant. An officer without a warrant arrest a person for a public offense committed in their presence. None of this was even committed in their presence, Your Honor. The arresting officer is coming on hearsay knowledge. The DTF officer showed up, and I'm already at Advanced Auto Parts. I'm not even at Exxon. So I mean, there was no ongoing crime. That's all I have to say, Your Honor.
General Bryson?
Judge, first I'd like to let the court know that Ms. Page is present. She will be testifying at trial. Because a suppression motion is a preliminary question under the rules of evidence, because we are determining the admissibility of evidence, the state may put on hearsay evidence, and that's what the state elected to do under Rule 104, preliminary questions A, questions of admissibility generally. So Ms. Page is here and present. So Judge, first of all, I'm a little bit confused what the defendant is trying to suppress. So you have his statements, which were made after he was asked to take a seat. He did make a statement admitting that he had held the door closed on the witness.
Objection, I didn't, Your Honor.
On scene, Judge, not today.
I would overrule the objection that this is argument rather than testimony by the district attorney, but I would point out that during representing yourself, and you asked Ms. Dozier the questions, and when she responded to say that, yes, you had gotten into an argument, you repeated her answers. So technically, the state is able to argue that you have made that statement.
I'm not here to make a testimony, Your Honor. I'm here to defend myself. I was not put under oath.
I understand that.
And Judge, the officers testified, Corporal Clark testified that the defendant told him that he held the door shut.
The objection's overruled.
Yes, Judge. So there was a dog alert on the car. The only thing obtained from the car, which could be argued subject to suppression, is the defendant's identification, which we're not entering into evidence, which would arguably be subject to inevitable discovery. So the only things I can see he's arguing to suppress are his own statements or his identifying documents. So the state is ready to proceed. In regards to the citation in lieu of arrest, the officers observed a continuing offense in their presence, which is public intoxication. And public intoxication, disorderly conduct, those are not offenses that the option to cite in lieu of arrest is available under 40-7-118, which is use of citations in lieu of continued custody or arrest. And if there is a danger of an assault continuing to occur, that is not eligible for citation in lieu of arrest. So, Judge, for the foregoing reasons, whatever he is saying should be suppressed, should not be suppressed, and this case should go to trial.
Anything else, Mr. Vaughn?
Yes, sir, Your Honor. Since the state's confused at what I'm trying to suppress here, Your Honor, let me inform the state that it is illegal against the Tennessee State Constitution and the Fourth Amendment of the United States to arrest someone without probable cause. To detain someone without having any evidence whatsoever, and clearly they still don't have the evidence here to produce today. No body cam footage, no witnesses that can testify that didn't make a statement that the state didn't help them come up with their own testimony here today, Your Honor. Continuing offense, everybody testified. I was at AutoZone when they showed up. So there's no continuing offense for the alcohol, Your Honor. There is no breathalyzer. There is no field sobriety test. There's no blood drawn. There's no proof that I was even drunk, Your Honor. The state can't even prove that. And to place somebody into custody and investigation, I don't even have all the cases here today, Your Honor, but one of them will be Bruton. You can't put somebody in the back of a police car and investigate something. It's illegal. And I was placed in handcuffs and held for a while, Your Honor. A legal arrest is a legal arrest, Your Honor. I don't care how you look at it. That's all I have for you.
All right, this is a motion to quash or dismiss with prejudice, and the grounds that have been raised has been that it was an illegal seizure under the Fourth Amendment because of the fact that the defendant argues that there is no probable cause for the arrest. The proof that has been offered at this hearing was that law enforcement responded to a report of a disturbance at the Exxon station, which also is involving, I think that's where there's a restaurant there. And as a result of that, when they arrived, the defendant had been moved, or at least when the Officer Clark arrived, the defendant had been moved over to the Advance Auto parking lot. But during the continuing investigation of what occurred, the proof has been, according to the state's proof, that the defendant was irate, that the defendant had a smell of alcohol about him, and that there was a report of there having been an assault and basically a false imprisonment by the holding of the door. The proof also established that the defendant, according to the officer's testimony, admitted that he had held the door, and by the defendant's own witness, it was established that he had gotten into an argument with the clerk in the Exxon station, and that when she attempted to apparently exit the store, that he held the door against her. So the court finds that there was, in fact, probable cause that a crime had been committed at the time the officers took the defendant into custody, and that their response was appropriate, and therefore it was not a violation of the Fourth Amendment because it was a continuing situation that simply had transferred from the Exxon station to the Advance Auto Parts. So therefore, the motion to quash or dismiss is denied, and the case will proceed to trial. We have other motions that the defendant has filed this morning. In general, I don't think you have had an opportunity to actually read through them. We'll take a short recess, probably about 15 or 20 minutes, and then we'll come back. And since he has put on these motions the case number of all of his cases, including the 337 that we're trying today, I'd like to go ahead and address any of those motions that we can and resolve all of those issues prior to the trial. The jury is instructed to return at 1 o'clock, so I am intending to start the jury selection process at 1 o'clock, if there's no reason not to. So.
Your Honor, can I brief my witness now?
The only way that you could brief your witness, and the thing is, you cannot tell a witness what to say.
I don't plan to.
When I'm talking, you just wait till I'm finished. When you want to speak to her and ask her the questions that you want to ask her, we can allow her to come into the area where the attorneys would speak to a witness. Mr. Vaughn would be, or to a defendant. Mr. Vaughn will be on one side, and she'll be on the other. If she's willing to talk with you, we'll allow that to happen. All right, we are ready to start to take up these other motions if they relate to the case that we're on trial for today. First one I have is a motion to reconsider, and that is Mr. Vaughn's motion asking for access to videos that are material evidence as he plans to prove due process violations and evidence required to file a proper complaint to the higher-ups, such as judicial conduct, board of professional responsibilities, risk management, and the appellant courts. And he's requesting under freedom of information. You want to address that issue first, Mr. Vaughn?
Yes, last time you stated that there was...
Mr. Vaughn, come to the podium, please.
There's numerous reasons why I'm requesting that information, these videos. Last time you stated that it was public knowledge, well, and for the fact that it may be public knowledge, and I'm incarcerated, and there's material evidence of due process violations and things that are, let's say that, like for instance, I requested for entirety of the things that were filed into my case. I feel like there's things missing. Like for one, your orders in this court ain't even in there. There's nothing in there for me, not one order that you, except for an order for the witnesses. And with it being part of the public Freedom of Information Act, it should be given to me, Your Honor. Yeah, and with the situation that I'm in, I mean, if it was public knowledge, I should be able to go get it. But being in the situation I'm in, I shouldn't be denied it just because of the situation I'm in. And that's my argument, Your Honor.
State have any response? Vaughn, I have previously ruled that those YouTube videos that you're asking to be downloaded onto some sort of a device that you could then review them, those YouTube videos are not evidence that can be used against you in court. And as a result, our appellate courts all operate from a written record, a transcript of the proceedings rather than any sort of video. They don't watch videos of cases that go up on appeal. Therefore, we are a public court, and those transmission or the publication of those videos has no other purpose other than to comply with the open courts policy that the Supreme Court has adopted. Therefore, they are not under the control and dominion of the state, and the rule is that under the rules of 16 for discovery and inspection that you're entitled to, that it provides that you're entitled to inspect and review any documents, photographs, tangible objects, including videos that are within the state's possession. These are not within the state's possession or custody or in control. And for that reason, you would not have the right to request those items to be provided to you. And as has previously been stated, they are public and can be viewed by you if you choose to do so or have someone else on your behalf do it. But as far as this court ordering that those have to be somehow transmitted or transferred onto a document or an item that you can then review and have in your possession, I'm denying that request. The next motion is requesting a sanction.
Excuse me, Your Honor. Who has access to them then?
Pardon?
Who has access to them? I mean, you have a camera right here.
The whole world has access to them.
You said, like,
all they have to do is go to YouTube and watch it.
I mean, I'm trying to receive access because, I mean, it is video evidence that I can prove my case. Without that, I can't prove my case.
Why?
Because the things happen on video and it's not even on audio. The same way I found out about things that happen on video, the due process happened on video. And then you said that the appellate court doesn't view video. I've read plenty of cases where they view videos, Your Honor.
I have no evidence before me that there is anything that would